of civil procedure. You, Mordue, Treece, law clerk, and court clerk. This is the inner sanctum of Americanism. The United States Constitution and the New York State Constitution. Page 8. The common law and the Magna Carta. Glendora charged you with all of the above. You did not deny them, ergo you admitted them. Merely 1/10 of the above puts you in violation of due process of law, of unbiased and unprejudiced, of incapable of making an objective ascertainment, perjury of oath, and consequent sections 3 and 4 of the 14th Amendment, no job and no pension. This is the same cell that press is in. You have not denied this, so it is admitted. Glendora is still refuting and denying the truth of your first page and the top of your second page. Treece, you concurrently omit was wrong press, was not served. Affluently, Glendora showed you that press was served by Federal Rules of Civil Procedure Rule 4D, and that press admitted that he was served. And what does this make Treece, the magistrate? It makes him a liar, a dunce, a fugitive, an impostor, a masquerader, and mentally unbelievable. Which one of those? All of the above? Further, Treece violated the United States Code. He did not have Glendora's consent in writing for authority to intrude. This is Title 28, United States Code, Section 636. When a United States magistrate judge violated the United States Code, this is rather a grievous offense. A United States magistrate violating a United States Code, a United States district judge violating the United States Code. I think we have here something that's pretty close to treason. Article 3, United States Constitution. Glendora is guaranteed all Article 3 judges. This trounces Treece with the same onus, Sections 3 and 4 of the 14th Amendment, no job and no pension. The 14th Amendment is a civil rights amendment, and Section 3 says that if a judge violates his oath, he loses his job on the bench and he loses his pension. And very serious is a United States district judge countenancing, assisting, conniving, seconding, supporting, sustaining, and upholding the same, Treece. All of the above brings into intense questioning the mental capacity of this court, Mordue, Treece, the law clerk, and the court clerk, and requests for psychological examination thereof. Glendora requested this, and it has been buried. Glendora charges that Mordue paper filed on November 2nd is deceiving and is intended to deceive. As to the, quote, pro se status, unquote, she, Glendora, repeats to its author another Title 28 being 1654. Title 28, Section 1654, pro se. In all courts of the United States, the parties may plead and conduct their own cases, personally or by counsel. Don't you ever hire a counsel, or at least a lawyer. You can have a counsel. By the rule of such courts, respectively, are presented to manage and conduct cases thereof, and it is not the vague and indefinite, that it violates the essentials of due process of law, secured by the United States Court annotated, which provides for self-representation. The duty of the court is implied in the right to self-representation and its obligation on the part of the court to make reasonable allowances to protect pro se immigrants, to protect pro se litigants from inadvertent forfeiture of important rights because of their lack of legal training. You know what legal training is, don't you? How to lie and make money. That's all legal training is. They don't know anything about the law. All they learn in law school is how you lie, cheat, and steal, and then make money. And include in writing Title 42 of the United States Code, Section 1983, which tells you that nobody is immune. Anybody, any person who violates your civil rights, who is a state actor, works for a government, you know, a municipal government, a state government, or a federal government, anybody who violates your civil rights is liable to you. Title 42 of the United States Code, Section 1983, every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory of the United or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured. So you see that? And every person is every judge, every clerk, every cop, every lawyer, every employee of a government. And press through bearment are all under color of any statute, i.e. a state actor. And append Title 42 of the United States Code, Section 1985, conspiracy. Mordue conspired with Press. Press conspired with a dirty liar for hire, Walter A. Sarok, and a liar for hire law firm, dirty. Sadly Stevens, Burke and Burke. Sadly Stevens, Jerk and Jerk. And again, we regurgitate Sections 3 and 4 of the 14th Amendment. You've lost your job in the bench, and you've lost your pension. Now, Glendora reserves. On this, she doesn't rest. She reserves. Now, beta. The remainder of Mordue, page 2, with 6 pages to go. Discussion. Objection to Magistrate Judge Treece's order. Well, they say within 10 days you can object. Well, I did. And they say that a magistrate can handle lesser details. But that's not so. That's not what the law says. And these were not lesser details, saying that the default judgment was denied. That's hardly a minute detail. And Treece said that Treece hadn't been, Treece said that Treece had not been served. Well, Treece had been served. I served him. And Treece admitted that he had been served in his 4-page atrocity of Terrorist Day, September the 11th. Just like the judges in a rut. I've got to get a new one. I think I've worn this one out. This was a particularly good one. It was a Sony. But that's a nice hymn. God of grace and God of glory, on thy people pour thy power. Grant thine ancient church's story, bring to bud her glorious flower. Grant us wisdom, grant us courage, for the facing of this hour, for the facing of this hour. And what is this hour? A chat with Glendora. And finding another two dirty judges in federal court. So there's 3 counts against Treece, and it's been delineated on TV in his hometown Albany. And Glendora makes the following cite, Ephesians 5, the fruit of the Spirit, goodness, righteousness, and truth. Fail on all 3. And what's he get paid? I don't know. A federal judge gets paid about $150,000 a year. So maybe a magistrate gets what? About $100,000? Your money. The same is first rate. All else is second rate. The real issue is goodness, righteousness, and truth, and Glendora ardently prays for the same for all involved. This court would do well, and court is always in quotation marks as far as I'm concerned. They are not a court. Would do well to attend to all of the 70s of the Federal Rules of Civil Procedure, how you file papers, how a magistrate gets into it, such as filing papers instead of returning them, and filing and reading and comprehending, that is, intercepting. And now we're up to Mordue's page 3 out of 8, 5 to go. And we're writing this on Veterans Day, or in that neighborhood, and they died in vain. What is a country without courts? Courts are the backbone of a country. And these are not courts. They're dens of lies and thievery and cheating. The court has reviewed the order dated October 10, 2007 and finds that it is not clearly erroneous or contrary to law. See Title 28, the United States Code, Section 636. And they're still talking and lying about Treece. Well, we know what he did. And Glendora says this is law clerk stuff, the first job out of school. Everything that this law clerk has scribbled is without merit. And Glendora commences this action on August the 23rd. And if this court had respected Federal Rules of Civil Procedure Rules 71 to 73 or 78 and filed instead of returned this error could have been avoided. That's what Behrman did. And this court says, moreover, plaintiff does not allege that the defendant press actually signed and returned the waiver of service to plaintiff. Well, I did. In my motion for default judgment, I said that I gave him 30 days, and his 30 days were up on September the 23rd. I gave him a few extra days, October the 1st, and then I filed my motion pursuant to Federal Rules of Civil Procedure, Rule 55, for default judgment. Well, I did do that. And so here they are, abetting and abiding the crook. Here are Mordue and Treece and the law clerk, the ghostwriter, and the court clerk, Behrman, abetting and abiding. This is off track, Glendora says. It's the wrong frequency and it's the wrong wavelength. It's sophomoric. Press acknowledge receipt of the service in his terrorist day paper of 9/11. 4 pages. If this court, quote unquote, had done its homework and read the 80-page attachment of September 29, 2007, instead of returning it, this ignorance and ignominy could have been circumvented. Admit, deny. Admit, deny. Epsilon. Further, this court, quote unquote, has committed again criminal title 18 U.S. Code, section 1001, cover-up of material fact. Your adumbration fails. Press was served the complaint August the 23rd, acknowledged the same in his 4 pages of 9/11, Terrorist Day. Submitted to this court, quote unquote, on 9/29. Press admitted it. I sent a copy of Press's admitting it to the court on the 29th of October. Admit, deny. You dig your hole more and more deeply. Foley Square will have to be an Arcades to pull you out of this one, out of this abyss. Zeta. The court says, in order to obtain jurisdiction over a defendant who has not signed a waiver of service, a plaintiff is required to actually serve the defendant with a summons and complaint, something that the plaintiff in this case did not do. Well, that's not right. That's not what happened. It's obfuscation. It's not the issue. It's deceiving and intended to deceive. It's Criminal Code 18, Section 1001, and it's fraud. Do you admit this, deny it, and give the grounds? Ada. Besides objecting to the terms of Magistrate Judge Treece's order itself, plaintiff seems to object, and seems to is lie number 10, to Magistrate Judge Treece's jurisdiction to take action in this case. Plaintiff challenges Judge Treece's jurisdiction on the basis that she did not consent in writing to having a magistrate judge act on this case. Well, baby, that's what the law says. A judge doesn't act, a magistrate doesn't act on the case unless the magistrate has the litigant's signature consent in writing. Admit or deny. You people have such difficulty comprehending plain Anglo-Saxon language. And this is page 18. Well, this law clerk says the plaintiff's argument is misplaced. And then the law clerk starts rationalizing. And Glendora says, and where is Glendora's consent in writing? This is More Criminal Code, Title 18, Section 1001, covering up material fact. Fine and jail. Admit, deny. What is misplaced is your obfuscation. What? This tape will be over at 11 o'clock. What is misplaced is your obfuscation, and what is misplaced is your accordingly. Anglo-Saxon accordingly, quote unquote, means following as a natural sequence, and yours doesn't. Accordingly, Magistrate Judge Treece, as the magistrate judge assigned in this case, had full authority to issue the order striking plaintiff's premature motion for default judgment. No way, Jose. Cover-up and trickery in its entirety, unequivocally, this self-surrender to vice is 18 U.S. Code Section 1001. And then Glendora goes on to fraud. Fraud is an intentional perversion of the truth. Listen to this and listen to it well, because it may happen to you, and I want you to have your protection. An intentional perversion of truth for the purpose of inducing another, with reliance upon you, to part with some valuable thing belonging to him, or to surrender a legal right through false representation of a matter of fact, whether by words or by conduct. Now, fraud can be committed upon you by words or by conduct, by false or misleading allegations, or by concealment of that which should have been disclosed, which deceives and is intended to deceive another, so that he shall act upon it to his or her legal injury. Now that's what Press did, that's what Mordue did, that's what Treece did, this is what this law clerk did, and this is what the court clerk did. Admit, deny, and grounds. Glendora charges you with even more acts of fraud delineated super above. There is no statute of limitation on fraud, folks. Theta. And while we are at it, your fraud nullifies your rulings, all of your rulings. This includes the following. Accordingly, plaintiff's objection to the order dated October 10, 2007 are denied, and the order is affirmed. This page 3 of your November the 2nd, 4 days before Election Day, is as shallow and fraudulent as your weak-kneed objection to Rule 8 and Rule 10, all procedural, Federal Rules of Civil Procedure, when you violated monumental Rule 38, jury trial shall be held inviolate. They pick up Rule 8 and 10, which are trivia, and then violate the monumental, which is denial of jury trial. I think we got to get a new one for you. When Glendora demanded the same on the caption of the lawsuit, it said jury trial demanded. right from the beginning. That's when I filed the complaint, August the 23rd. And you violated Glendora's unalienable rights to discovery. Federal Rules of Civil Procedure, Rules 26 and 37. And then they chirp about Rule 8 and Rule 10. How you're supposed to have margins, and how you're supposed to have a simple complaint, and how you're supposed to have the paragraphs numbered. Yeah. Was there concern that they violated discovery, which is due process of law? Federal Rules of Civil Procedure 27 to 37, and Rule 38. Jury trial. Further, you double-crossed your own circuit. Meaning, this it's a Second Circuit decision, 1995, Glendora versus the Cablevision Systems Corporation, Charles F. Dolan. Let's see, who else? William J. Bell. Francis Randolph. John Tata, James Kofalt, Joseph Asnara, Thomas Garger, William Quinn. Defendant appellees. When the Second Circuit, Charles Bryant dismissed the case, and he lied when he did it. He just out and out lied. The dates were set in concrete. And so it was remanded by the Second Circuit back to Bryant to do it over and do it right and rule in Glendora's favor. And the grounds were that a pro se civil rights case cannot be dismissed until the pro se civil rights litigant has a chance to prove fully the case. And of course, this is not what Mordue did. He did just the opposite. He dismissed it instantly against press on the phony grounds of immunity, which we have shown does not exist. So far, these 3 pages do not answer Glendora's submissions. 1, her complaint filed on August the 23rd, her 80-page attachment of September the 29th, her Rule 60B motion of Halloween, October the 29th, her findings, questions, charges, and demand for omissions of October 29th, Halloween. Glendora received 3 envelopes one from Mordue, one from Treece, and one from the clerk. The one from Mordue dismissed press as a defendant with no legality or no factual basis at all. Treece's was saying that the default motion was not only denied but stricken. See how dirty they are, how they cover up the record? Well, it's still in the record. You can lie all you want, Treece. You can lie all you want, Mordue, law clerk, and court clerk. But you don't change the facts. Okay, the facts are still there. And the 3rd envelope was Behrman returning the 80-page attachment that I had written against press's stupid 4 pages of Terrorist Day, September the 11th. And I received those on October 18th. And October the 18th is Franklin's Ascendancy Day. 4 years ago, 2003. Issues in each of the above have not been addressed nor answered. Again, it is penumbra and no core. You know how the sun, the core and then the penumbra? This is all penumbra and no core. Master Uli took Glendora's TV show off of TV by scaring away Glendora's local signers. This is the original case that was brought in the White Plains City Court. And Glendora